So the agent's powers for a Section 7 rep agreement, you can deal with personal matters about decisions about where and with whom the person is to reside. You can do routine management of financial affairs, paying bills, receipt, deposit of income into a bank account, although again the bank might want a specific form signed by the bank, as banks are banks. You can obtain legal services, except you can't apply for a divorce with a Section 7 rep agreement. Just the statutory limitation. You can consent to routine medical procedures, but you cannot refuse life-saving medical treatment. So if you're in that situation, you've got to go through the public trustee because, again, the Queen, the King, has a responsibility for taking care of his or her young subjects. And so that's a statutory limitation. Agent under a Section 7, where you're dealing with somebody with lower capacity, the agent cannot have the person physically restrained. Because again, in order to do that, you've got to go through one more level of authority. So you're going to have to get a court order to do that because you need the supervision because the person didn't have full capacity when they gave the document. There are certain things where you can't consent to electroconvulsive therapy or removal of tissue from the body for organ donation, experimental treatment. Again, going to have other people involved in that just because it's you're dealing with somebody who had lower capacity. So that's a list of things. Now, if you are in a situation where you have to have a Section 7 agreement, where the person has lower capacity, you have to appoint a monitor. And a monitor is sort of like a referee. Would that be fair? If you did philosophy in university, Plato had the concept of the guardian, and then he had the question of, well, who will guard the guardians? So as the representative, you're the guardian, but now you have a monitor to make sure that, who can supervise you and report to the public trustee that you're doing everything that you should be doing, because again, you're dealing with somebody with less capacity at the time. The exceptions are no monitor needed if your representative is your spouse. I guess that makes sense because, my wife would rule the roost anyway. If the representative is the public guardian and trustee, well, the Queen is going to trust herself. If it's a trust company or a credit union, because they're already regulated through different authorities, or if you appoint more than one representative who has to exercise all authority unanimously, because now you've got checks and balances. It's a checks and balances system. So if you've got two people, they both have to agree. That's enough of a safeguard. Because again, the emphasis of this legislation is safeguarding people who might be vulnerable. Mm-hmm. Now, you can, with the power of attorney, you could also do a power of attorney where you have a monitor. Yeah. But if you're doing that, that means you don't trust the person you're appointing. So you got to think about who you're appointing in that case. We've had people ask about that, but our question back is, well, if you don't trust the person, should you be appointing somebody else? Now, sometimes people don't have anybody, and they need to put in a safeguard. But that's very situational. So even if you don't have to appoint a monitor, you can always choose to appoint a monitor if you don't have, and again, it's if when you have that image of you're in a coma, who do you want by your bedside? If you say, well, there's nobody I really trust implicitly, then you might have to have a monitor to protect against abuse by the agent. Because, of course, the public trustee can supervise abuse by the agent, but by that time it gets to the attention of the public trustee, it's usually too late. The money's gone. Did you want to talk about public guardian? I've been going on, sorry.
Sure, no, that's fine. So public guardian and trustee, as Blair mentioned, government agency. Any person can make an objection if they want to. For example, as we said, if someone objected and said that that person didn't have capacity to make this agreement, they can object to this particular government agency. As I said, about incapable, or if the agreement seems like it's just inconsistent with what you know of that person and you're worried, you can contact the public trustee. Then the public trustee has a legislative responsibility to conduct an investigation and see if there's any merit to this objection. And they can also, if there's no objection whatsoever, they can also just kind of be monitoring things and decide to do almost like an audit, go in and check things out on their own. So they have the power under the statute to conduct investigations on their own if they're concerned.
Yeah. So if the situation is that there's a disagreement among the relatives and somebody might say, you know, I don't like this, that's where, if you set up the representation agreement and you have a lawyer involved, that can be very useful because the public trustee is going to contact the lawyer and say, okay, tell me about when this agreement was signed. Did the person have capacity? The lawyer is going to hopefully have extensive notes, because you always keep extensive notes when capacity might be an issue, and the lawyer will be able to satisfy that, as opposed to, oh, it was my neighbor across the road who doesn't know anything about capacity. They just came in and said they saw the person sign. So that's going to be a completely different focus on the investigation, and the public trustee is going to have a completely different reaction. So I would recommend, and it's not just because I'm a lawyer, I would recommend that you have the agreement signed in front of a lawyer, just because you have to assume that capacity might become an issue at some point. Support networks. When you're dealing with planning for the child, you know, the question is going to be, when I'm not around, what's going to happen? So Lifetime Networks will provide a network of friends, and they'll have, I think they charge a fee for the service because they have administrative expenses, but they will organize, you know, sometimes university students who want to do some volunteer work, and, you know, it could be a long network, or it could be just somebody who comes in and then people change. But there's somebody who can provide some social support.
And Lifetime Networks is in Victoria. So the other reason that I wanted to change this slide is because it was quite Victoria-centric. Sorry about that, that's where we're from. But now this is a little bit more for the whole province. So Inclusion BC covers the whole province, and they have a fantastic website with a lot of links to other organizations. Really, really useful website. And then Plan, I don't want to give any specific endorsement because I don't know much about them, but they're here in Burnaby, and for a lifetime membership fee, they'll help you out with that. They do courses like this, so they'll do, I think, a 2-session course on wills and different things like that. So that's here also in the Lower Mainland. And Inclusion BC, its office is in New Westminster. So there's some Lower Mainland specific groups.
So you're not restricted just to family. You can also use these groups where people
They connect families. That's what all these groups are about, connecting families.
Yeah.
Specifically, Plan is a network of families that work together. Inclusion BC also, Lifetime Networks, they're all not-for-profit organizations as well. So Inclusion BC and Lifetime Networks is a lot more about sort of events and creating community. Plan is a lot more, it looks to me, again, I haven't spoken with anybody from Plan, so not a specific endorsement, but a little bit more of a training for you as parents or whatever. So more information-based, and the other two are more sort of community and events-based.